Assalamualaikum and hello everyone. My name is Nur Azman bin Hadisel. I am leader from Tutorial 1 Group D. My group member is Abdul Muhaimin, Aiman Azri, Nur Saniza and Hasma. So we will explain the issue, rules, application and conclusion each question provided.
Assalamualaikum warahmatullahi wabarakatuh. My name is Abdul Muhaimin bin Ahmad. Okay, now for question 2A, the question is in the second transaction, another ship belonging to Liverpool Shipping Corporation (LSC), the Caribbean, was on fire after loading completed, but before the beginning of the voyage. The fire had caused the cargo owned by Comfy Fotia Co. Ltd. CFC that was on board totally destroyed. LSC again rejected the claim of the cargo owner, arguing the duty to ensure seaworthiness was limited only to the period of the commencement of the loading and not after loading had been completed. Okay, so the first issue is, did a fire occur on Comfy Footwear Co. Ltd. CFC cargo is an insurable event? Okay, so the rules is based on Section 3, Article number 2 of the Maritime Insurance Act. There is a marine adventure where the earning or acquisition of any freight, passage money, commission, profit, or other pecuniary benefit, or the security for any advance, loan, or disbursement is endangered by the exposure of insurable property to maritime perils. Okay. Second is, any liability to a third party may be incurred by the owner of or other person interested in or responsible for insurable property by reason of maritime perils. Okay, maritime perils means the perils consequent on or incidental to the navigation of the sea, perils of the seas, fire, war, pirates, rovers, thieves, capture, variety, and any other perils either of the like kind or which may be designed by the policy. Okay, so the application. Okay, in this situation, Liverpool Shipping Corporation (LSC) has agreed to provide sea freight service to Comfy Footwear Co. Ltd. CFC to deliver cargo belonging to the company to its destination using a Caribbean vessels. Okay, upon completion of the cargo unloading period on the ship, there was a fire on the ship which has caused the cargo belonging to Comfy Footwear Co. Ltd. CFC totally lost. Okay. Comfy Footwear Co. Ltd. CFC has claimed damage for the cargo belonging to the company that was burned on board. Pursuant to Section 3, Article 2, states that fire is one of the maritime risk category. Okay, this section clarifies that a fire that occurred aboard an LSC on Caribbean vessels was an insurable incident in which Comfy Footwear Co. Ltd. CFC can claim damage for their goods. So the conclusion, pursuant to Maritime Insurance Act, Section 3, Article number 2, a fire that occurred on a Caribbean ship belonging to Liverpool Shipping Corporation (LSC) is an insurable event in which Comfy Footwear Co. Ltd. CFC can claim damage to the transportation service provider on the burned cargo. Okay, now I'm talking about the issue number 2. Okay, so issue number 2 is Comfy Footwear Co. Ltd. CFC is entitled to claim damage from Liverpool Shipping Corporation (LSC) before the ship starts sailing. Okay, so the rules is based on Section 39, Article number 2 states that where the policy attached while the ship is in port, there is also an implied warranty that she shall, at the commencement of the race, be reasonably fit to encounter the ordinary perils of the port. Okay, for the application, in this case, the cargo belonged to Comfy Footwear Co. Ltd. CFC was ready to be unloaded on a Caribbean vessels belonging to Liverpool Shipping Corporation (LSC) before sailing to its destination. Okay, While the ship was still in parking condition at the port, a fire broke out on a Caribbean ship where the fire had cargo items belonging to Comfy Footwear Co. Ltd. CFC has disappeared altogether. As a result of the incident, Comfy Footwear Co. Ltd. CFC seeks compensation for cargo that has been borne on board a ship belonging to Liverpool Shipping Corporation LLC. Okay, based on Maritime Act Section 39, Article number 2, indicates that while the policy of the ship is in the port, okay, they require attention to the risk of maritime perils that are common in the port. Okay, this suggests that shipping companies in the LSC need to act against all risk of maritime hazards occurring in the port, and ships have not yet voyaged to exit the port. Okay, due to a cargo fire belonging to Comfy Footwear Co. Ltd. CFC occurring on board and vessels not required in transit. This use the LSC required to obtain damage to Comfy Footwear Co. Ltd. CFC against their cargo that had caught fire on a Caribbean ship. Okay, so for the conclusions, Comfy Footwear Co. Ltd. CFC reserve the right to claim damage from Liverpool Shipping Corporation LLC for the fire that broke out on their cargo, which caused the cargo to be totally lost while on board LSC Caribbean vessels. Okay, this claims is based on the Maritime Insurance Act, Section 39, Article number 2, which states that the shipping company still bears the risk in the event of maritime perils while the ship is still in port and has not moved. Okay, that's all for me. Thank you.
Assalamualaikum. My name is Asma binti Aziz. Today I'm going to answer for the question A, which is Liverpool Shipping Corporation LLC is a shipping company dealing with carriage of goods and based in Liverpool, United Kingdom. LLC had employed a firm of reputable and reliable repairers to repair their ship, the Swan, before sailing. Nevertheless, they were negligent in rendering their service and caused water to enter into the ship's hold, damaging the goods belonging to the Fresh Meat Co. Ltd. FMC. The cargo owner brought an action against LSC. LSC, however, denied their liability and argued that they had discharged their burden when they delegated the responsibility of making the ship seaworthy to a firm of reputable and reliable repairers. The issue in this case is Liverpool Shipping Corporation responsible to the damaged goods belonging to the Fresh Meat Co. Ltd. Or is the repairers the LLC had employed responsible to the damage? The rules that gonna be used in this case is based on the Hague-Visby rules. The Hague rules are amended by the Brussels Protocol 1968, which are from the Article 1, bracket A, bracket B, bracket D, and bracket E. Also from the Article 4, 1, 2, bracket A, bracket Q, and 3. The other rules that will be used is based on United Nations Convention on Contract for the International Sale of Goods 1980, CISG Section 2. Damage Article 74 damage for breach of contract by one party consists of a sum equal to the loss, including loss of profit, suffered by the other party as a consequence of the breach. In this case, Liverpool Shipping Corporation LLC is a carrier based on the Article 1, bracket A, in the Hague-Visby rules. Fresh Meat Co. Ltd. FMC has been chosen the LSC as the carrier for shipping their goods. But something happened where the water entered the ship and it's damaging the goods belonging to the FMC. FMC brought an action against LSC. LSC, however, denied their liability and argued that they had discharged their burden when they delegated the responsibility of making the ship seaworthy to a firm of reputable and reliable repairers. Based on Article 4, 1 and 2, neither the carrier or shipper will be responsible for the damage. So LSC would not be responsible for the damage that happened to the goods belonging to the FMC. However, based on Article 1 bracket E, carriage of goods covers the period from the time when the goods are loaded on to the time they are discharged from the ship, but in this case, LC had employed a firm of reputable and reliable repairers to repair the ship, the Swan, before sailing. Nevertheless, the firm neglected and rendering their services, causing the ship breakdown and enter the water. FMC must take the burden to prove which side should be blamed and take the responsibility towards to the ship damage and the damaging goods based on Article 4(2) bracket Q in the Hague Visby rules. On the other hand, the party that will be responsible must pay compensation based on CISG 1980 Section 2, Article 74, where the damage for breach of contract by one party consists of a sum equal to the loss, including loss of profit, suffered by the other party as a consequence of the breach. In this case, the party that will be responsible for the damage to the ship and goods was the repairers firm that had been hired by the LSC. This is because they are careless and negligent while carrying out tasks where they do not carry out proper inspection on the ship before ship sail. In conclusion, based on the case, LC will not be liable for damage to FMC goods as the damage to the ship occurred due to the negligence of the repair company. That's all from me. Thank you.
Question B, number 1. Issue number 1. Is it fair for the shipper to blame the carrier in this situation? According to Article 3, Responsibilities and Liabilities Section 1C rules pertaining to bills of lading issue under the Carriage of Goods by Sea Act of 1950 indicates the before and at the start of the voyage. The carrier is obligated to use reasonable care to ensure that the hulls, refrigerating and cool chamber, and all other areas of the ship in which commodities are transported are fit and safe for their reception, carriage, and preservation. So, in this situation, it's clearly shown that Samsung agreed to sell the Fish to Green Ltd in New York. However, it was the fault of its official who put the temperature on the fish in the refrigerated container above the set or required temperature. However, I think the situation can still be saved with the action of the carrier who should be responsible for placing the goods in the refrigerator and cool room to prevent the goods from being damaged. In conclusion, the carrier should be blamed by Samsung for their negligence in placing Samsung goods in the proper place to avoid the fish from smelling bad and being rejected by the recipient. Issue number 2. Whether is Samsung to be blamed for the negligence committed by his employees who put the temperature above what it should have been in the fish container and at the same time does not nothing the transporter of the goods contents. According to Article 3, which is Responsibilities and Liabilities Section 8, the Goods Carriage by Sea Act of 1950 show that any clause, covenant, or agreement in the contract of carrier releasing the carrier or the ship from liability or loss or damage to goods arising from negligence, fault, or failure to perform the duties and obligations set forth in this article, or lessening such liability in any way other than as set forth in these rules, shall be null and void and of no effect. A benefit of insurance or similar clause is deemed to be liability releasing clause for the carrier. In this instance, Samsung is not entitled to claim loss or insurance due to the carrier failure to properly handle the cargo because there is an agreement or document of agreement between the shipper and the carrier before delivery, this is a basic mandatory things. Moreover, damage to the goods is due to negligence of the shipper himself need to be acknowledged. The conclusion clearly shows the carrier should not be blamed as the offender and Samsung himself should be held accountable for the wrongdoing committed by his employees. Thank you.
Assalamualaikum and hi everyone, my name is Norsani Zanuddin and I'm going to present the third issue of question B1, where the issue is whether the buyer, Green Limited, has the right to reject the delivery from the carrier, which is Quaker, due to the leaking some fluid and also emitted smell from the container, which is contain 200 cartons of codfish from Samsung. In this case, it is fall under Convention of International Sales of Goods CISG 1980 because the relationship between them, according to the Article 35 sub 1, the seller must deliver item in the quality, quantity and description specified in the contract as well as in the container or packaging specified in the contract, which means that the contractual description of the product is the deciding factor in assessing whether the item follows the contract. As a result, the features are not based on objective quality standard, but rather on the contract designation and description of the needed quality. Based on a situation, Samsung had delivered 200 cartons of codfish as they are agreed and already delivered to the Green Limited New York, but unfortunately, the Green Limited reject the delivery due to the leaking some fluid and also emitted smell from the container, which shows the goods are being damaged. Hence, it is shown that Samsung fell under the Article 35 sub 1. Also in Article 46, if the item do not meet the contract's requirement, the buyer may ask the seller to repair the non-conformity, and unless this is unacceptable in the circumstance, thus the buyer is eligible to ask the Samsung for substitute the 200 cartons of damaged codfish and not accepted the delivery. In Article 49 sub 1a, if the seller failed to fulfill any of his responsibility under the contract or this convention, in a fundamental breach of contract, the buyer may declare the deal avoided, which means it gives the right to buyer to declare the contract between them. Under the Article 66, the buyer is not relieved of his obligation to pay the price if the goods are lost or damaged after the risk has passed to him, unless the loss or damage is caused by the seller's act or omission. This means that the buyer had it right to reject the good and not obliged to pay for it due to the damage of the goods. Hence, Green Limited has the right to reject the delivery from Samsung. In conclusion, Samsung cannot blame the Green Limited for not accepting the delivery of the 200 cartons of damages codfish. That's all for me. Thank you.
Assalamualaikum, my name is Ayman Azra ibn Azhar, and today I am going to present question B2. The issue regarding this question is Samsung personally liable for the loss of the olive oil? Whether Samsung is personally liable or not depends on whether the risk of loss has been transferred between the seller, which is Samsung, and the buyer, which is Hamlet. As per the Byron & Co. Limited vs. India Navigation Co. Limited 1954 case, FOB is described as all expenditures up to the loading of the goods onto an overseas vessel designated by the buyer are included in the price paid to the seller. The property and risk normally pass to the buyer once the goods are loaded onto the vessel. All the additional costs that follows after are the buyer's responsibility. The Byron & Co. Limited vs. India Navigation Co. Limited 1954 case, which was later affirmed by the Court of Appeal in the case of the El Amria and El Minya 1982, states that second variant of the FOB contract, which is extended FOB, is applied in the situation where the seller makes the shipping arrangements that include nominating the vessel, and making a contract of carriage. As per Frebel and Sturzenegger, 1970, the arrival time at the port of destination is irrelevant. And as per the Byron and Stock versus Inglis, 1884, the risk in the goods passed together with property on shipment once the goods pass the ship's rail. Samson agreed to sell 1,500 bottles of olive oil to Hamlet, FOB, London to Denmark, March shipment. In this situation, the seller, which is Samson, bears the full responsibility and liability for the cost and safety of the 1,500 bottles of olive oil, but only until to the point where the goods pass the ship's rail, as described in the case of the Byron and Co. Limited versus Indian Navigation Co. Limited, 1954. The statement under the contract, Samson agreed to make shipping arrangements, shows that the second variant of FOB is applied in this case. This type of FOB contract is in line with the classification of FOB contract in the Byron and Co. Limited versus Indian Navigation Co. Limited, 1954, which was later affirmed by the Court of Appeal in the case of the El Amria and the El Minia, 1982 case. Samson, the seller, agreed to make the shipping arrangements according to the contract. Therefore, the contract falls under the second variant of the FOB contract. In this case, Samson did not make the contract of carriage directly with the carrier, which is Polonius. Instead, he employs Alex, a freight forwarding agent, to book a shipping space aboard the Polonius, where 1,500 bottles of olive oil can be loaded and stowed. However, the ship, which is due to arrive in March, does not arrive until April 2nd. It is Samson's duty to make sure the goods are delivered on the agreed upon date, but in an FOB contract, the seller is considered to have delivered the goods to the buyer once the goods cross over the ship's rail. Samson has managed to deliver the 1,500 bottles of olive oil to Hamlet since the oils have passed the Polonius rails. The fact that Polonius arrived on April 2nd when the ship is supposed to arrive in March is irrelevant, as per Frebel and Sturzenegger case, 1970. According to the Byron and Stock versus Inglis, 1884, the risk in the goods passed together with property on shipment once the goods pass the ship's rail. Hence, the responsibility and risk are now passed to the buyer, which is Hamlet. Since Samson has managed to perform his contractual duties by delivering the 1,500 bottles of olive oil to the carrier, which is Polonius, Samson no longer bears the liability since the goods have passed the ship's rail. The conclusion is, based on the preceding analysis, it is clear that Samson has completed his contractual duties and no longer bears the risk in the goods since the goods have passed Polonius's rails. Hence, I would advise Samson to claim the price from Hamlet for all the expenditures and safety he bears up until the point where the goods have passed Polonius's rails.